Hi, this is Professor Higgins, and we are getting to the close of our business organizations class. This week, we will be taking a look at termination of the corporate existence. The textbook does a really great job on this chapter, so take a look at chapter 12. And we're going to be discussing this week. Our focus is dissolution of the corporation. So we've learned what a corporation is. We have learned how to create or form the formation of a corporation. We've learned how the management occurs in a corporation and the business is run. And then we are now to the point, if the corporation is going to have an end, you know that corporations generally, unless stated elsewhere in their bylaws or articles of incorporation, that a corporation generally lasts forever. It's perpetual. But when it is going to dissolve, it can dissolve in three different ways: voluntarily, or involuntarily, or by judicial mandate. There are judicial dissolutions. So I want to give you a little idea about how each of these occurs and how they work. And let's jump right in here. Let's see. There are instances where a corporation will elect to end its corporate existence. And I want to start with a couple of terms that are important. Dissolution, which is the ending of the corporation, is the legal termination of the corporate entity. So when we say dissolution, that's what we're talking about. It is completely and utterly gone after dissolution. There is another term that I want you to know: liquidation. And liquidation is the process of winding up the corporation. The liquidation has to occur prior to the dissolution. So it involves figuring out what the corporation's assets are, paying the debts that the corporation owns, distributing any residual property or proceeds, if there are any, to the shareholders. Basically, the winding up is the liquidation portion. And a corporation is either going to be voluntarily dissolved or involuntarily dissolved. Now let's talk about the voluntary dissolution. A voluntary dissolution occurs as a result of a voluntary decision by the corporation to dissolve and end and cease to be in existence any longer. They've decided, for whatever reasons, they're just tired of doing it. It's not making money anymore. For whatever reason that they decide, they can just stop being a corporation. There are two types of, well, there might be three actually. A dissolution prior to the commencement of the business is regulated by or governed by Florida statute. And that's in 607, or chapter 607, which is all in corporations, point 1401. This is when the corporation hasn't even really gotten off the ground. It has started to function. It's got everything in line. They've paid their fees and they've done everything that they need to, but it never got started, and so now they just have to dissolve it. This is pretty rare, but it does happen, and there are very specific rules for how to do this. The majority of the incorporators or directors of the corporation that has not issued shares or has not commenced business may dissolve the corporation by filing the articles of dissolution. That's a $35 form on Sunbiz, and those are the two times when it can be dissolved prior to business starting. The form is a simple fill-in-the-blank form. You need the name of the corporation, the date of filing the articles of incorporation, that either no shares have been issued or that the corporation has not begun to do business in the state of Florida, that there are no corporate debts that are unpaid, and if there is any net assets, they have been distributed to the shareholders. Okay, generally, in this case, there's not going to be. What happens is you got your shareholders together, you did everything legally that you had to do to get started to be a corporation. But before business started, you just decided, never mind, we decide not to do this for whatever reason. And you don't have to disclose that reason. You just, on a whim, can say, no, you want to do this after all. The majority of the incorporators or directors have to authorize the dissolution. So it's a simple majority. Then there is a type of dissolution that occurs after the commencement of business. This is 607.1402. And this can happen in two ways. The board of directors recommend dissolution to the shareholders, and the majority of all the shares entitled to vote must agree to dissolve the corporation unless the articles call for a different percentage. Be careful. You have to notify every single shareholder of this proposal, and you have to state the purpose of the meeting. So every single shareholder has to know that we're getting ready to meet, and we're getting ready to meet to dissolve the corporation. That's very important. Every shareholder gives written notice or consent pursuant to Chapter 607.1404 by agreeing to dissolve the corporation. So if every single shareholder decides they want to dissolve the corporation, then it can be dissolved. And either one of these happens, either number one or number two happens. Once that happens, then you file the articles of dissolution. After the next C part here in your notes is the revocation of dissolution. Now, because the state of Florida loves corporations, and they love them for so many reasons, they hate to see them dissolve. But the state of Florida, corporations mean more business being done, more taxes being collected, more revenue being made, more jobs in the economy of the area. So government hates to see them shut down. So once you have voluntarily dissolved, you have 120 days to change your mind and sort of, let's get the band back together again. This isn't as good idea as we thought it was going to be. Let's keep going. You can, if you file the revocation of dissolution, that means that the dissolution that you went through, the activities that you went through, all the steps that you took to dissolve the corporation are just revoked, and everything is put right back to where it was. Revocation of dissolution is a corporation this is what the statute states. A corporation has 120 days after voluntarily dissolving to change its mind and to revoke the dissolution. This process is as follows. Number one, they must authorize, it has to be authorized in the same manner as the dissolution was authorized. So if you had 100% of the shareholders saying, we want to dissolve the corporation, then you have to have 100% of the shareholders saying, no, we changed our mind. We all want to keep the corporation. If you had it done by a majority of the shareholders, then you can put it back into place by a majority of the shareholders. Then you have to, of course, file the articles of revocation of dissolution, along with another $35 and a copy of the articles of dissolution to the Department of State. And it is effective upon filing. The articles of revocation of dissolution state, number one, you have to have the name of the corporation. You have to have the effective date of the dissolution. And the third thing is you have to have the date that the revocation of dissolution was authorized. When revocation of dissolution is effective, it takes effect as if the effective date of the dissolution and the corporation resumes carrying on its business as if the dissolution never occurred. Okay, if you don't, however, if you don't revoke your dissolution and you've decided to voluntarily dissolve, and you've done so, then you go through the liquidation process. This is just where you finish up, wrap up all your old business. You don't take any new business. And the liquidation process, the effective dissolution is authorized basically by Florida statute, and again, that's 607.1405. A dissolved corporation continues in its existence, but may not carry on any business except to wind up the affairs of the business. It's allowed to do these following things. Even though it can't take new business, it can collect its assets together. It can dispose of its property. It can discharge liability and pay off its debts to creditors. And it can then distribute whatever property, the residual property that's left, it can then distribute that to the shareholders. And that's done proportionately based on if somebody owns 50% of the company or has 50% of the shares, then they get 50% of whatever's left, the profits, or that little pile of money at the end. The name of the dissolved corporation, it's going to be there. It's in your notes. I'm not going to start the state cite the Florida statutes every time we come to them, but there's a Florida statute that states that in the name of the dissolved corporation shall not be available for others to use. No other corporation can come along and say, hey, that was a great name. Let's pick that name up. Nobody can use that name after the dissolution for 120 days. After the effect of the dissolution. And why is that? Well, if you think about it, you've got those 120 days to change your mind and revoke the dissolution. So no one can take that name. You've got 150 days to decide that. Once those 120 days. You've got those 120 days to decide. And if you don't in 120 days, then somebody else can pick up your name. But for those 120 days, nobody has the name of that corporation. All right. So you've decided to dissolve your corporation. You're not going to change your mind in 120 days. So you just continue to go forward. The next thing that you're going to do is give notice to your creditors. And it's just like a limited partnership. The corporation has to deliver to each known creditor a written notice of dissolution which contains this following information: a reasonable description of the claim to which the creditor may be entitled, state whether or not the claim is admitted, mailing address where the claim may be sent, the deadline by which the creditor must deliver a confirmation of claim of corporation, and it cannot be more than 120 days. And it must state that the corporation may seek distribution thereafter to other creditors and to the shareholders. Now, the corporation may need to post a bond with the circuit court for unknown creditors and for those who contest what the corporation says it owes. So you send a notice to all your creditors and you say, hey, I think we owe you this much money, and here's the paperwork that says why. And then they have to say, yes, that is what you owe us. And then the corporation will send that money and make sure that they get paid. So they're winding up all of these things. If, however, the creditor says, no, it was a little more than that, then there are statutory procedures by which they can, dispute the amounts and stuff. But generally, In business, records are records, and they're pretty well set, and people keep good records. And so if someone says, hey, we're filing, we think we owe you this money, we're getting out of the business, we are dissolving, then they let you know, and they send you a bill, or what they think is their last bill, and you go, yep, that's what you owe us. You confirm that, and then the corporation that's dissolving can just pay that bill and be done with you as a creditor. The payment that goes out from the corporation as it's winding up, the first entities that get paid are not the shareholders, they are the creditors. The creditors get their money in full first, and then secondly, the money that's left in the pot after the creditors have been paid then goes to the shareholders. And as I said a second ago, they're paid proportionately, in proportion with their ownership interest. All right, and of course, we can't do anything without our tax considerations. There's always going to be tax considerations. The dissolving corporation must notify the IRS by filing a Form 966 together with a copy of the plan of liquidation, plus a report liquidation form. There's two forms, Forms 1096 and 1099. So know that when you are dissolving a corporation, you're going to have tax consequences, and so you're going to have to get an accountant involved. All right, so that is how voluntary dissolution occurs. Let's see, involuntary dissolution. The involuntary dissolution is exactly what it sounds like. It's dissolution which is forced upon a corporation by the state or by the courts. Okay. Generally, the more common involuntary dissolution is by the state. Here, of course, it would be by the state of Florida. There is administrative dissolution where the state dissolves the corporation. And you have to know this. The grounds for dissolution from statute, this is in Florida statutes, 607.1420. If you fail to file the annual report or pay an annual report filing fee, then the state of Florida will dissolve your corporation. And this is the most common. And the way to get around it is you just pay those fees, and there's going to be penalties so that the state can get their money, but it's not a huge deal. It's a big deal in that you want to be proper and you want to set it up correctly and have your you don't want to be involuntarily dissolved. But if your client comes in panicked, your attorney's going to tell them to settle down. We can take care of it. No worries. The other thing, there's four that I want to go through with you where dissolution, where the state dissolves the corporation. The second one is the corporation fails to maintain a registered agent for more than 30 days. So you have a registered agent, and let's say your registered agent says, I don't want to be the registered agent anymore. I'm retiring, or I'm moving out of state, or I'm for whatever reason. And the corporation says, that's fine. We'll just have someone else do it. So that person is no longer the registered agent. You have 30 days to find another one. If on the 31st day they look around and you don't have a registered agent, they're going to dissolve your corporation. So you want to get somebody else in there pretty quickly, but you have 30 days. But if you just piddle around and you don't get someone lined up to be your registered agent, then you're going to be dissolved. All right, number 3 is the corporation fails to respond to the state's interrogatories. Now, we have interrogatories in litigation, but anytime the state sends the corporation a list of questions, you have to answer them. You have to respond to those, because if you don't, that's right, your corporation will be dissolved. Number 4, the corporation's period of duration in the articles has expired. If you do say in your articles of incorporation that you are going to run this corporation for 3 years, then at the end of 3 years, even if you forget, at the end of 3 years, if you have not gone back in and amended your articles or put something in your bylaws saying that you want to continue, you're going to be dissolved. So just know that. And sometimes people forget, they think, oh, we'll do this for 3 years, and then things get up and running. In a couple of years, it really takes off, and they're surprised, and everything's going gangbusters, and well, they forget, and then their 3rd year rolls around and the state dissolves them. So have to watch out for that kind of stuff. All right. In the involuntary dissolution department, the corporation has 60 days. Like if you have a problem and the state is saying, we're going to dissolve you, here's notice. The state has 60 days not the state, the corporation has 60 days to resolve the problem. If not, the Department of State administratively dissolves the corporation by issuing something called a certificate of dissolution that recites the grounds for dissolution. So you get notice that they're about to dissolve you. And then if you don't fix it in 60 days, then they issue the certificate of dissolution. All right, the effect of being dissolved, the corporation cannot carry on any new business, and it has to actively start winding up its affairs. If any new business occurs after the dissolution, any director, and this is important, any officer, any agent of the corporation, any shareholder may be personally liable for the debts, obligations, or other liabilities of the corporation arising from such action. So you do not want to do any additional business. Don't let that corporation do any. And I think I said shareholders, not the shareholders. It's just the directors, the officers, and the agent. They are all setting themselves up for potential personal liability exposure. So when you get involuntarily dissolved, you need to start winding things up. Note, you can seek a reinstatement pursuant to Chapter 607, 142. Again, it relates back to that corporation can resume doing business if the administrative dissolution never occurred. Also, you can appeal a denial of reinstatement, and Florida statute gives you very clear steps to take when you want to do that. Because like I said, the state wants to have corporations. They want to have businesses running, and they don't want things to dissolve. All right, the last one is the judicial dissolution. This usually is due to fraudulent behavior by the corporation, and it's forced on them by the court. So when the court dissolves you, that's like the biggest and baddest. That's kind of for keeps. A circuit court in the county where the principal place of business is located may dissolve a corporation in a proceeding by the following. The first example of it is they go to the Department of Affairs, and they accuse the corporation of fraud, that they have fraudulent activities. The second, the shareholders, if there is an irreconcilable deadlock that the corporation is stuck in, you have 4 directors, or you have 8 directors, 4 on one side, 4 on the other side, and no one's going to change their mind. You're deadlocked. One of the directors or one of the shareholders will go to the court and say, hey, we're at a debt impasse. We're just going to be stuck here treading water and forever, so we need to be dissolved. We're at what they call irreconcilable deadlock. Okay, and then the last one for judicial dissolution is when the creditors ask for it. That's when someone is not being paid what they're owed, and usually creditors are being defrauded. So they've been promised something for payment, and then the corporation does not hold up its end of the bargain, and so the creditors take it to court, and the court says, you're done. They dissolve you. Generally, there's a trial, and then the court enters a judgment of dissolution, which specifies the effective date of the dissolution. The clerk of court delivers a certified copy of the judgment to the Department of State. So now the Secretary of State knows that this corporation is no longer in existence, that it's been dissolved. Those are the three ways that corporations are dissolved. And like I said before, I want you to remember that the state hates dissolution. They hate to see it because there's loss of jobs in their community. There's loss of revenue because they don't have all these fees and things that corporations tend to generate, as well as taxes. The more money that they make, the more taxes that they're going to be able to collect. So the state likes corporations. That's all I have for this week, or not this week, but for this lecture. And make sure that you go on and see the next lecture, because we will be discussing foreign corporations and what happens with mergers when the corporate structure changes. So I will see you in a few minutes.